Konuklar.
You need to push, I guess. Okay.
Değerli konuklar, ülkemizde gelenek oldu. Bulunuyoruz. Şimdi öğleden sonraki oturuma başlıyoruz. Ama bundan önce toplantımıza gönderilmiş varıyorum da. Toplantımıza gönderilmiş oldukça fazla sayıda kutlama telgrafları var. Onları hızlıca sizlere aktarmak istiyorum. Uluslararası Tahkim Uygulamaları ve Türkiye konulu sempozyuma nazik davetiniz için teşekkür ederim. Bilgi ve deneyimleri paylaşılacağı ekonomik bir platforma sahne olacak bu sempozyumun başarıyla geçmesini diliyor. Hazırlanmasına emek verenleri tebrik ediyorum. Değerli katılımcıları en içten dileklerimle selamlıyorum. Recep Tayyip Erdoğan Başbakan. Nazik davetinize teşekkür ederim. Önceden kesinleşmiş olan çalışma programı nedeniyle Uluslararası Tahkim Uygulamaları ve Türkiye Konu Sempozyuma katılamıyorum. Tüm davetlilere selam ve saygılarımı sunarım. Faruk Nafiz Özak Devlet Bakanı. Buyurun. Öyle yapacağım. Ahi Evran Üniversitesi Rektörü Profesör Sebahati Kudret, Egemen Bağış Devlet Bakanı Profesör Doktor Hüseyin Altaş Ankara Üniversitesi Hukuk Fakültesi Dekanlığı, Bekir Bozdağ Yozgat Milletvekili, Ahmet Adnan Okur Nallıhan Belediye Başkanı, Rıfat Hisarcıklıoğlu Türkiye Odalar Borsalar Birliği Başkanı, Nevzat Pakdil Kahramanmaraş Milletvekili, hala öyle midir bilmiyorum. Öyle mi? Cemil Çiçek Devlet Bakanı, Mustafa Kumlu Türk İş Genel Başkanı, Nevzat Pakdil konuştuk galiba, Kahramanmaraş Milletvekili, Ali Rıza Öztürk Mersin Milletvekili, Avukat Ayşe Türkmenoğlu Konya Milletvekili, Hüseyin Avni Mutlu Vali, Hasip Kaplan Şırnak Milletvekili, Gazi Şahin Elmadağ Belediye Başkanı. Gördüğünüz gibi toplantımız Türkiye çapında gayet başarıyla duyurulmuş bulunuyor. Şu ana kadar ulaşan kutlama dilekleri bu şekilde. Bundan sonra gelen olursa onları da uygun bir arada sizlere iletmek istiyorum. Şimdi bu oturumumuzda dünyadan çeşitli tahkim uygulamalarıyla ilgili değerli konuklarımızdan bilgi alacağız. Bu programımızdaki sıralamaya göre yapmak istiyoruz sunumları. Bu nedenle ilk sırada Sayın Vladimir Kıvalay'ı ICC Tahkim Mahkemesi Başkan Yardımcısı. Kendisine sunum için mikrofonu kendisine veriyorum.
Thank you very much. I've got limited time to talk about ICC rules. Okay. And I start with bad news. And the bad news is that ICC arbitration is the most expensive arbitration in the world. This is why ICC is criticized for being expensive. From other sides, number of cases is increasing from year to year, and I'll try to explain why, despite of being expensive, ICC arbitration is still so popular. Here you see a chart with number of cases, and in last year there were 793 cases. Number of cases slightly decreased. However, number of parties increased, and almost 30% of cases which are submitted to arbitration under ICC rules are multi-party cases, i.e. the cases where more than two parties participating. I also made a special extract from statistics with regard to companies from Turkey being parties to ICC arbitration. There's no statistic yet available for 2010, but you could get from this chart that in 2009 there were more than 60 parties from Turkey participating in ICC arbitration. And again, this chart shows that there is a tendency of increasing participation of Turkish companies in ICC arbitration. And also what is interesting with Turkey is that there are some cases where none of the parties is non-Turkish. So there are some arbitrations where both parts, the claimant and the respondents, are from Turkey, which also evidence the confidence Turkish companies have in ICC arbitration. With regard to the city of arbitration or place of arbitration, indeed Paris, London, Geneva, Zurich were the most popular places for arbitration for many reasons. But in some cases, Turkey was also appointed or designated by the parties as place of arbitration. Not a lot. You see here from this chart that in 2002 there were 10 cases where Turkey was a place of arbitration. In 2009 only 4, which is evidence that parties, even Turkish parties, do not consider Turkey as a safe place for arbitration, i.e. friendly place for arbitration, because parties mainly choosing the place of arbitration not only because of geographical convenience, but also for arbitration law and court practice being friendly to arbitration. And when parties are trying to avoid a particular country or city to be a place of arbitration, that's a sign that usually parties do not have confidence in this place. But this is something for Istanbul and Ankara Bar to think about, how to make Turkey more attractive place for arbitration. With regard to language of arbitration, majority of the awards were drafted in English, and then we have French awards, then Spanish awards, German, Portuguese, and also there were some awards which were drafted in Turkish language. For you who are not familiar with ICC rules, and I believe with many other arbitration rules, if arbitration clause provides that arbitration must be conducted in Turkish language, arbitration will be conducted in Turkish language. With regard to choice of law, English law is the main law which was applied by the tribunal according to the parties, choice of the parties. However, there were also Swiss law, French law, and some other laws applicable. I had this morning discussion about applicability of English law and how to deal with this issue. From my perspective, my experience, the best advice is simply put in writing what you want to agree or you want to regulate with your business partner. Because usually in arbitrations, the arbitrators respect parties' agreement, and they pay more attention to the party agreement than to any applicable law, because it's usually a problem when you negotiate a contract which applicable law should be chosen, because one party insists on its own law, the other party on the other party's law, and sometimes parties agree on a neutral country law which is unfamiliar and both parties are unfamiliar with this law. And sometimes this third country law comes as a surprise to both parties. So this is why the arbitrators, they like when parties put in writing what they want to achieve with the agreement. So if you are uncertain with regard to New York law or English law or German law, simply put in writing what you want to see in your contract, and I think that in 95% of cases the tribunal will respect your choice. When it comes to appointment of arbitrators, ICC, unlike other arbitration institutions, relies on national committees. To understand how ICC operates, there are more than 90 national committees around the world, and Turkey is also one of the members of ICC as organization, and there is also one representative of Turkey in ICC court. It's Dr. Akinci, who is not present here. And he participates as member of ICC court from Turkey in plenary sessions. Sometimes he participates in committee meetings of the court, but I'll come to this issue later. ICC court doesn't have a list of arbitrators. And the way how ICC appoints arbitrators in case one party does not appoint an arbitrator looks as follows. If, for example, there is a Turkish respondent and Turkish respondent does not appoint an arbitrator, then ICC goes to Turkish National Committee, and Turkish National Committee of ICC propose candidate to be appointed on behalf of the Turkish company. This proposal is not final because under ICC rules, court has authority to confirm or not to confirm arbitrators. But in vast majority of cases, ICC court usually confirms the arbitrators either appointed by the parties or proposed by national committee. Why ICC does not confirm? Because ICC looks not only into qualification and experience of arbitrators and knowledge of the language of arbitration, but also ICC court starts to pay a lot of attention to availability of arbitrators. If you had experience with arbitration under ICC or some other rules, you might had experience in the past when you were expecting a award, for example, for 8 months or 10 months after the end of the final hearing, which from my personal perspective is absolutely unacceptable. And why it happens so? Because arbitrators are overloaded with cases, so you could have very good names, very well-known arbitrators, they're speaking at conferences, making nice presentation, nice speeches, however, they have too many cases to handle. And there were cases in the past and currently cases when ICC court replaced at its own initiative arbitrators who are underperforming, i.e. could not effectively manage arbitration or could not deliver a award within reasonable period of time. But the problem and why this system, this arbitration world is not perfect, that if, for example, today ICC court replace an arbitrator who cannot deliver a award, for example, in 12 months after the final hearing, next day we could see appointment of the same person by some other company, because this company is not aware about replacement, and they still appoint the same person because they read his book or see him or her on a conference and they see, well, it's a good specialist. So for such cases, ICC court first of all introduced a special form statement of availability of arbitrators, where potential arbitrator notifies the court about a number of cases where he or she sits as an arbitrator or as a chairman or as a counsel. So the court has idea what is the workload of an arbitrator, and this form is sent to the parties. But also court has discretion not to appoint, not to confirm arbitrator proposed by the parties, because ICC court, for example, had some bad experience with this arbitrator. Although some practitioners criticize ICC court for doing it, but I think it's a good system. I've got here a chart which could give you an idea how many arbitrators were appointed by the parties, proposed by national committees and appointed by the court, and you could look into it later. How ICC court works, there are several levels of ICC court. The first level is secretariat level. Then there is a committee court level. Committee consists of chairman or vice chairman of the court and 2 members of the court who participate in committee, and plenary sessions of the court. Plenary sessions of the court are conducted every month, last Thursday of every month, and plenary sessions are attended by all members of the court from around the world, and they are dealing with the most important issues. And most important issues are awards in arbitrations where one of the parties is state or a state company. The awards where there is a dissenting opinion of one of the arbitrators, and challenges and replacements. And although it delays, in some sense, arbitration, because again, unique feature of ICC arbitration is that the award is not final when it's signed by arbitrators. When tribunal drafts the draft award goes to ICC Secretariat. Then ICC Secretariat checks the award. This is a process called scrutiny. And then it goes either to the plenary session or to the court committee meeting, where members of the court also read the award and check the award. This is a really, really good feature because, this is a really, really good process because when I was appointed as vice president of ICC court, I was really surprised how many mistakes actually are making arbitrators. And these are mistakes with calculations, because we are all good as lawyers in legal reasonings, but we are very bad in numbers. Although clients are going to arbitration for numbers, but lawyers hate to deal with numbers. So somebody, when they're checking all calculation is draft award, and almost every award consists of some arithmetical mistakes. Also, there are some other mistakes made by arbitrators. For example, arbitrators do not deal with all the claims submitted by the parties. ICC is well known as good for dealing with complicated case. And when you have construction dispute, quite often you have 18 claims from a claimant side and 12 counterclaims from respondent side. And then you see in the final part of the award, in this positive part of the award, that there are decisions only with regard to the 12 claims only. And then you start to think, well, what happened to remaining claims? And quite often you realize that the arbitrators simply did not deal with them. Or, for example, sometimes arbitrators going beyond the scope of the claims submitted to them by the parties. It is a function of ICC court to make everything possible to make the arbitral award enforceable. So therefore this scrutiny process works in a way that from one side it eliminates mistake made by the tribunal and also give some assurance that this award will be enforceable, because it's a common knowledge of members of ICC court from different countries. And they could say, for example, if the award is to be enforced in Serbia, a member court from Serbia could say, well, in order this award to be enforceable in Serbia, some more arguments should be added, for example, on such and such issues. And I could tell you, it also gives a guarantee to the parties that the award is well-reasoned and well-balanced. There were cases, for example, when plenary session did not approve the draft award and agreed with dissenting arbitrators. Although in many cases, dissenting opinion of arbitrators is done for many reasons which are not reasons not related to real issues. But sometimes dissenting arbitrator has very good point. And then ICC court draws attention of the remaining arbitrators to this particular point. So this scrutiny system why ICC is very popular in the world, because if you have major dispute, it does not really matter whether you pay a little bit more or a little bit less as fees for arbitrators or for institution. What is important for you is that you got well-reasoned and balanced award. And this ICC system, it makes, it double checks the award and eliminates mistakes and make very high quality awards. What other issues? Origins of arbitrators also. Here's the chart for 2009. As you can see, there were also Turkish arbitrators appointed in 2009. Total amount of 13 arbitrators. So this chart shows that not in every case, because you remember the number of total parties from Turkey participating in ICC arbitration. So not in every case, Turkish companies appoint Turkish arbitrators. This is the chart also for the last 10 years, showing that arbitrators from Turkey are quite often appointed as co-arbitrator and as also as chairman of the tribunal. With regard to procedural features, I told already you about confirmation of arbitrators by ICC court. I told already about national committees. Again, for you to understand how the system works with chairman, because it's very important to have a good chairman when you have arbitration. And when the parties do not agree on the chairman is appointed by ICC court, but not directly. ICC usually goes to the national committee. For example, if you have a dispute between German company and Turkish company, and German company appoints, let's say, Swiss arbitrator, and Turkish company appoints Turkish arbitrator, then ICC court needs to appoint the chairman. The chairman would never have the same nationality as the party, so the chairman would never be German or Turkish. The chairman would never have the same nationality as party-appointed arbitrator, so he or she would not be Turkish or Swiss. And the court will go to a neutral country, to a neutral national committee to propose potential chairman. Which country is usually chosen by the court? Several issues are usually considered. First of all, applicable law, language of arbitration, place of arbitration, sometimes industry knowledge if it's necessary. For example, if you've got, in my example, German law as applicable and German language, then ICC would probably go to Austrian National Committee, because in Austria Austrian legal system is similar to German system, so we could have Austrian arbitrator with knowledge, of course, of German and with some knowledge of how German legal system works as a chairman of the tribunal. If you've got English law, but for example, one of the companies appoint English arbitrator, ICC court would never go to UK National Committee to propose the chairman, but ICC would ask, for example, US National Committee or Canadian National Committee or Australian National Committee to appoint the chairman who is familiar with common law principles, speaking language of arbitration. So we'll also always have neutral tribunal, neutral to both parties, neutral to party-appointed arbitrators. And again, ICC court, when looks into the candidate proposed by National Committee, check whether this person is able to conduct arbitration in the best way, whether this person is available. And there are cases when ICC court does not confirm candidates proposed by national committees for reasons either because this person is not experienced enough to deal with this dispute or overloaded with cases, or there are some other reasons. In terms of reference, this is also a unique feature of ICC arbitration. You don't have it under any other rules, and many practitioners, they criticize the system, these terms of reference, saying this is not what parties really need because terms of reference is additional stage in arbitration, it delays proceedings, it makes it more complicated. Yes, it's right, it's additional stage in arbitration, it delays proceedings, but why it's useful? What is terms of reference? Terms of reference is a document which is drafted by the tribunal and signed by the parties. When the parties put all their claims which were submitted to this particular tribunal to decide. It does not have indeed a lot of sense to have terms of reference when you have straightforward disputes. For example, one party delivers goods and the other party does not pay. You don't need to put terms of reference. But if you have 10 claims from one side, 10 claims from the other side, sometimes parties formulate their claims in very unsophisticated way, if you want, because in a case of non-payment, for example, under the contract, they don't formulate their claim asking tribunal to order the other party to pay. They are asking tribunal, first of all, to issue declaration that the other party is in breach of the contract, to issue declaration that this party is not in a breach of the contract, to ask for declaration that whatever, that the claimant of the other party is not, the counsel for the other party is not entitled to participate in arbitration because of conflict of interest. So sometimes there are a lot of claims or demands, if you want, which were put before the arbitrators, which are not perfect from a legal perspective. So when tribunal sits together with the parties and tries to agree with them or crystallize the claims they have, dispute quite often becomes less complicated first. Quite often parties could settle it after signing terms of reference or at the time signing terms of reference, because when they crystallize their claim, they realize that there are not so many differences in their approaches. So the terms of reference is a tool which is used by ICC court to scrutinize the awards, because when draft award comes to ICC court verifies whether all the claims which were submitted by the parties to ICC court were dealt with. So these are the most important features of ICC arbitration. There are new rules coming into force next year. They'll be officially launched, very few in July, I guess. Just briefly about what is new in ICC rules. The main features of ICC arbitration will remain the same. What is new under ICC rules? First of all, there are some provisions dealing with efficiency of arbitration, allowing tribunals to have hearings by video, audio conference, using means of electronic communications, so make arbitration more efficient. You are probably familiar with publication of ICC Time and Cost in International Arbitration. And in this publication, ICC recommended to use various techniques to make arbitration more efficient and less costly. Some of the recommendations from this publication will be attached to ICC rules as some of the mechanisms which could be used and agreed by the parties in order to make arbitration more efficient. Secondly, there will be some more provisions dealing with multi-party arbitration. Because, as I mentioned before, almost one sort of cases are multi-party cases, as they're very complicated to deal with. Because when you have, for example, a claim, when one claimant files a claim against two respondents, and then one of the respondents files a claim, counterclaim, not only against the claimant, but also against the other respondent, and asking also the third party to be joined as another respondent. So then you have a lot of issues related, for example, to appointment of arbitrators, how the third party joining this arbitrator could influence appointment of arbitrators. You have issues related to allocation of arbitration costs and fees among the parties. So there will be provisions in ICC rules dealing with these issues. There's also provisions, there will be new provisions related to emergency arbitrator, because currently you cannot, under current version of ICC rules, you cannot get interim measures before tribunal is appointed. And so under new rules, there will be opportunity to have emergency arbitrator. For example, if you file request for arbitration and you need immediately to take decision on interim measures, there will be a possibility to appoint so-called emergency arbitrator. But there will be a lot of conferences, I'm sure, in the next few months. So if you are interested in new rules, you'll know about it. But the system as such will remain as it is. So it will not be significantly changed. And to summarize, as I started, ICC system is expensive system. It does not fit for a minor dispute. You should remember it. When I are talking about minor disputes, it's not just disputes below 1 million. Sometimes even if it's 2 or 3 million, it's not good for it because it's too expensive. But when it comes to major disputes, when it comes to complicated disputes, this system works perfectly well. Thank you.
Thank you. İzin verirseniz... Sanırım, evet. Bu mikrofonu çalışır tutmak da ayrı bir maharet gerektiriyor. Kusurumuza bakmayın. İzin verirseniz sorularınızı saklayın. En sonda hepsini birlikte alalım. Belki konuşmacılarımızın birlikte katkıda bulunacakları bölümler olabilir veya sizin sorunuz bir sonraki konuşmacı tarafından cevaplanmış olabilir. O yüzden doğrudan ikinci konuşmacımıza geçiyoruz. Sayın Profesör Doktor Daniel Girsberger, Luzern Üniversitesi Hukuk Fakültesinden, kendisine mikrofonu veriyorum dinlemek üzere. Need help. Close it. Okay. It's not opening. Okay.
Ladies and gentlemen, thank you very much for staying and for listening. I'm very happy to be here. Being a Swiss, I feel close to you, especially as a Swiss lawyer, because we are based on the same private law system, and also until not all too long ago we had very similar civil procedural laws. It still is the case, but the reform has taken place in both countries now. So you have given up the Neuchâtel Civil Procedure Code, we have given up 26 cantonal procedural codes. But we are still affiliated, I'm sure, and I'm also happy to see many Turkish lawyers come to Switzerland, study Swiss law. I hope that there will be more Swiss lawyers studying Turkish law because they can learn a lot from you. Among others, I have learned a lot from your new Private International Law Act because it was 7 years earlier than ours. And I have also learned a lot from your new 2007 Arbitration Act, because ours is now 20 years old or 30 years old and should be reformed. Yours is not as old, but it has a touch of Switzerland. It has a touch of UNCITRAL, it has a touch of Switzerland. So that reassures me that we are still on the same level. I'm not sure whether you have received this presentation. If you want to get it, this is my email address. It's very easy. Where is the app? Thank you. Oops. not the same when you apply.
Doların yerine iyi koyacaksınız.
That's my email address. You can write me an email and I'll send you the presentation, or you can drop me your card or your email address and I will send it to you, so I don't have to go into all the details. I'm both a practitioner and an academic. I practice arbitration in Switzerland. You have seen on my colleagues' list that the Swiss arbitrators are very numerous. I'm happy to be one of them sometimes, both in ICC and in other proceedings, but I'm also teaching arbitration and contracts in a newly founded university 10 years ago. We founded it in the center of Switzerland, Lucerne, so not Zurich, not Geneva, Lucerne. If you haven't visited it, it's worth a visit. But I practice in Zurich. Now I can skip the slides that come because they were all covered by earlier speakers today. I don't have to explain anymore what is a typical arbitration setting. I don't have to explain anymore the differences between state court litigation on the one side, which is to your right, and mediation ADR on the other side. It's clearly in between is arbitration, but it has common traits, of course, with litigation, state court litigation, in that it is ending in a binding decision which can be enforced. There are a lot of points that have already been covered about the advantages of arbitration and, of course, also the disadvantages. Even very experienced arbitrators, I heard today, are skeptical about arbitration sometimes. I am also sometimes skeptical, but I think for international commercial transactions, this is the common dispute resolution mechanism. Whether it's the same for domestic dispute resolution is another question. But for international cases, I think court litigation is much more burdensome, especially because of the New York Convention, which is the treaty that unites us all, or at least 150 states of this globe that have ratified it, and on which basis, at least in theory, but also often in practice, awards from abroad must be enforced in any other member state. This is the typical arbitration procedure. My topic here is institutional arbitration in Europe, so I'm supposed to tell you what in the institutional settings. Here is the common denominator. Most arbitral proceedings are conducted in this order. You have an initiation, which is the request for arbitration. Then the tribunal is formed, and there we see differences between the various institutional rules, but the biggest difference is between so-called ad hoc proceedings and institutional arbitration, because in ad hoc proceedings you don't have an institution that helps you form the arbitral tribunal. But for the rest, most or many of the functions that go with an institution are to help you form the institution, the arbitral tribunal, and that's a very important function of the institutions in many cases. Then you have the procedure with the exchange of written memoranda. You also have nowadays more and more the so-called document production phase, which in the eyes of a lot of us are a problem, becoming a problem because they delay the proceedings and are used for delaying tactics. So many lawyers nowadays say if it continues like that, that arbitration will not be much more than a US-style litigation, and therefore should be abandoned as a dispute resolution mechanism. In certain cases, they're probably right. The so-called witness statements are something that are not known to civil law-based jurisdictions such as Turkey or other Western European countries. They come from the US, but they are helpful in international arbitrations because when you read the file before the hearing starts, it contains very often so-called witness statements in writing, so you have a basis on which you as the arbitral tribunal can prepare your questions or clarify what is still needed in the so-called witness hearing. Witness hearing normally during 1 to 20 days, depending on the size of the matter, is very often concentrated in one hearing in which all the parties and their witnesses and the arbitral tribunal gather notice of arbitration and where the evidence is taken. This is a common denominator, again, of all European institutional rules. And then, of course, the deliberation phase and the award, hopefully soon. Some of the institutional rules provide for a strict time limit for the award, but it can be extended. I will come back to that a little bit later. And then, of course, the award may be challenged in court. We have heard about that this morning, and it may need to be recognized or enforced. And here the doubts, of course, that have been formulated this morning arise if such recognition does not occur. The legal sources are different from those for court litigation, and I think that's a very important factor, because arbitration is based on party autonomy. Arbitration rules that are chosen by the parties are very important, and that's a difference to court litigation where you don't choose the rules, you are given the rules by having to follow the Civil Procedure Acts. But also in arbitration, if you go up the pyramid, you have mandatory rules, and those mandatory norms are those, most of the time, of the place of arbitration. We have heard about that, and they may curtail your party autonomy, especially in terms of the challenges that can be brought to the award. They are mandatory, except for the waiver we heard that is possible in certain jurisdictions, but only very few. They are mandatory, but not much is mandatory in arbitration. And then, of course, you have the treaties, which are, of course, binding and mandatory, but they normally are in favor of arbitration rather than curtailing arbitration. And I'm speaking again of the New York Convention. So that's the legal basis on which you conduct your arbitration proceedings. We call this lex arbitri, which is normally the law at the place, at the seat of the arbitration. I'm not talking about domestic arbitration. I think now the new act in Turkey is only governing international arbitration. Right. Same in Switzerland, for example, but there are also many jurisdictions where the legal framework is designed for both types of arbitration, such as the German Civil Procedure Act. Talking about institutions in Europe, if I had wanted to draw them all on this picture, I would not have had enough room, so I made a choice, and I hope you forgive me if your favorite institution is not on this map, but those that have the most cases certainly are. And I'm only talking about Western Europe. Of course, in Eastern Europe, arbitral institutions are rising like mushroom, and there is also, of course, your Turkish Chamber of the Istanbul Chamber of Commerce that has its own basics. But we heard from our colleague that there is a lot to do still, and we hope to see that there is institutional arbitration within Turkey as well. I don't speak as a competitor, but as a lawyer who wants the best result. So you see, going from north to south, the SCC, the Stockholm Chamber of Commerce, which has a well-known institution, with its own rules, very often used for parties in the Far East, like China, and of the West. That is very often used and well known. Then you have the Netherlands Arbitration Institute that has been there for a long time, which has quite a few cases every year. Going to the West, the LC, London Court of International Arbitration. We heard from our colleague that he's a member of the board, a very important institution. Sorry, not of the board, but it can happen in the future. London Court of International Arbitration, it's not a court, it's a private institution. It's called London Court of International Arbitration. I think it's about 150 years old. Has a lot of cases. I will show you the statistics a little bit later. It's the Belgium arbitration, international arbitration institution. DIS is the German one, the Deutsche Institution für Schiedsgerichtsbarkeit. And now you know from which part in Switzerland I am. And the ICC is, of course, the most important European arbitral institution. We have heard from our colleague just a few minutes ago. Then going to the far east in this painting is the Vienna Chamber, which has used to have a lot of cases, especially between the old Eastern Bloc country companies or entities and the West, a little bit less now. Then Switzerland has the Swiss chambers that have united for creating an international arbitral setting. So the Zurich Chamber of Commerce, we have heard this morning, still exists, but it's based on the same arbitral rules, which are the Swiss rules of international arbitration. We will see that in a moment. And of course the Chamber of Arbitration in Milan, of which we will hear in a few minutes more. So these are the institutions that are commonly known and kind of equivalent, I would say, with regard to their rules. And I might say even of their services, but of course there are differences. Now, I have tried to make a list of the number of arbitrations, so you can see a little bit where in Europe how many cases are dealt with and where there are statistics. Of course, with regard to ad hoc proceedings, since they are not administered by an institution, or very, very rarely are administered by an institution, you don't have numbers, you don't have statistics. But you have the statistics of ICC. It's all 2010. We heard the number already several times today, 793 in 2010. The CAS, of which we have heard this morning as well from our colleague, Turkish colleague, has a lot of cases, 298, specialized institution, followed by the LCIA, then by the German institution, which has taken up quite some speed in the last years, followed by the Milan Chamber, and then by the Swiss chambers. So that's about the numbers that are known within European institutional arbitration. The number of awards, it's counted a little bit different in every institution, so it's difficult to interpret those here. As I said, ad hoc proceedings are not administered by an institution, but of course they are often governed by an institutional, a set of rules that has been there and used often, and that's the UNCITRAL arbitration rules. They are used very often in ad hoc proceedings, sometimes even in institutional proceedings. They have been revised, as we heard, and our colleague in the audience has told us a little bit about this revision, so I won't go into that. Here I can show you the result of a survey that was conducted last year by a big law firm in the United States in cooperation with a university in London, the Queen Mary University, that deals a lot with international arbitration. They have conducted a survey and asked about 140, gotten about 140 answers in writing to their inquiry, and they also conducted about 70 interviews with counsel, in-house counsel and external counsel in the area of business arbitration. They showed this result within their research. ICC is used by 50% of the respondents, LCIA by 14, then AAA, of which, of course, I haven't spoken so far because it's not a European institution, but it has its European branch, 8%, the Singapore Arbitration Center, 5%, then the Japanese Commercial Arbitration Association, 4%, the Hong Kong International Arbitration Commission, 4%, and then others. We still wait to get an explicit mention in the next years. So in ICC I don't have to explain anything because it has been done so much more professionally by my colleague. Maybe interesting the amount, of course, under $1 million US, only 24.1%. That means there are a lot of big cases in the ICC. Of course, I am prone to talk a little bit longer about the Swiss chambers of arbitration. I won't do much. It just helps me a little bit to show you what types of cases can be dealt with in international arbitration, institutional in Europe. You see we had 89 cases in 2010 and 47 in 2006. We had a little fall in 2010, but the number had doubled from 2006 to 2009. And you see how many cases are accepted, most of them because, of course, they have the basis in an agreement between the parties, but 8 of them were not sufficient, apparently. That's why only 81 cases were accepted. You see here the parties, the origin of the parties, most of them coming from Western Europe. And you can analyze these figures when you have my slideshow at home. I don't have the time, unfortunately, to go into much of it. What I wanted to show you here is that 2 types of proceedings that the Swiss rules have. They have the so-called normal proceedings and they have the so-called expedited proceedings. The normal proceedings, they don't have a time limit. Of course, they must be conducted efficiently, and the average of the proceeding that is conducted under these rules normally is not more than 2 years, but they also have an expedited proceeding. The expedited proceedings are in place when the parties agree upon them. This means an award has to be made within 6 months, and I have personally encountered such awards. they are enforced by the institution as much as possible. Or if the amount in dispute is less than $1 million US. So then the expedited proceedings take place, and in such cases they are conducted, unless the parties agree otherwise, by one sole arbitrator, because of course that is more efficient and also less costly. And that is reflected also in the numbers for the tribunals. In the second table, you see that 60% of the Swiss proceedings were conducted under a sole arbitrator, and only 1/3 were conducted by a 3-member tribunal. And this sole arbitrator proceeding has grown in importance considerably from 2006, as you can see. Here you see a little bit what types of proceedings are conducted under the Swiss rules. Most of it is similar in the other chambers. The percentages are very similar because there are general institutional arbitration and specialized institutions. Swiss chambers are a general commercial institution, as are the Milan chambers, as is the Stockholm, as is the LCIA, as opposed to specialized institutions such as the CAS, of which we have heard quite a bit this morning, and therefore I can skip this. But maybe you are interested in the numbers of the CAS, and you will be able to see it. What you can see here is that in the next table, you can see that the appeals procedures are much more numerous than those procedures that are so-called ordinary procedures. That means that the parties have to agree upon the arbitration, whereas in appeals procedures, that is in the statutes normally of the sports federation of which they are a member. The LCIA, 1892, many proceedings per year. The amount has doubled since 2006. They have only 50% of cases above $1 million, so you see they also, as opposed to the ICC, have many more small arbitration or smaller arbitration proceedings. And they're very international as well, with 83% of non-British parties. 50% sole arbitrators, 50% 3-member tribunals. This is a very bad picture because I had to copy it from a website. It's what Vladimir already alluded to, the costs of arbitration. You were very modest because it's not the most expensive. You see the black pole at the very right is DIAC. That's the Dubai International Arbitration Center. And you also see one that is quite high, which I am afraid to say is the Moscow International Chamber.
It's Moscow, yeah.
So those two are the most costly, and unfortunately they not only are the most costly, they don't have an excellent reputation all the time, at least not in the White and Case study. But that can change.
I'm happy not to be there.
Yes, me too. This time we are happy not to be part of that. But you see the cost is different. It depends on, I should say that not only the cost of the arbitration proceeding paid to the arbitral tribunal and the institution is important. I think as important is what the parties pay to their attorneys, and if an arbitration proceeding is not administered well, that cost might outweigh the costs paid to the arbitral tribunal and the institution. And you have to bear in mind that the cost of the arbitral tribunal normally is about a 1/5 or a 1/6 of the cost associated with paying attorney's fees. So that puts it into dimensions. I think it's also important to know the influence of the state courts. If you are confronted with institutional arbitration in Europe, because they can affect both the time and the cost of an arbitration. I think there cannot be any doubt about this. Here, I think Switzerland is a good example because there is only one instance to which you can appeal, and our colleague has several times alluded to this Swiss Federal Supreme Court. In other jurisdictional systems, you have more than one appeal. But of course, as our US-American colleague said this morning, not only does it matter how many instances for an appeal, but also what is the grounds for setting aside. If they're narrow, you won't even go up to the first instance. If it's a broad ground, you may have a lot of possibilities to attack a decision. So that must be taken into account also when choosing an institution in Europe. What is the lex arbitri? What is the law of the seat that you are choosing? For example, I found a table based on a research of a colleague of mine at the University of Neuchâtel that showed, based on also studies, empirical studies, that it can vary quite a bit whether you go to a place of arbitration such as Switzerland, which has only 5 months average appeals time or challenge time to the Swiss Federal Court, or to Sweden, which still has 15 to 20 months, or even to France and England, that takes several years. And last but not least, the chances of success have to be taken into account too. So how many chances are there to succeed with your challenge of the arbitral award? So, in summary, I tried to list the success factors for a place for arbitration, and if you are speaking about Istanbul Chamber of Commerce arbitration, you will certainly have to take these factors into account when you work on this project. I think that are the factors that make an institution for arbitration attractive, and most of these factors you will find also in the empirical study that I was talking about from White and Case and Queen Mary. Interestingly, most of the respondents, namely 2/3 of the respondents, said that neutrality and the interregionalism was what mattered most to them. So we are in good position in Switzerland, but you in Istanbul may be in a very good position in the Near East, because you are the most neutral country, I should say, of all countries around you. So that would be a possible advantage, I think, of institutional arbitration here in Istanbul or elsewhere in Turkey. Then the reputation and recognition. Of course, everyone has to work on that. 56% of the respondents said that mattered also very much. And third, already the arbitral rules. So there the differences between the rules, the setting between the institutions may matter. Choice of substantive law also matters. We have heard what the importance is of what law is chosen to govern the dispute. Previous experiences, of course, the overall cost of which we have talked, and the global presence of an institution. Those are the 7 factors that were rated most important by the 140 respondents of that White and Case study. In summary, there are not many differences between the institutions, not many differences between their arbitral settings, but this framework that counts when you wish to advise your client or to choose yourself a place of arbitration. If you want to learn more about institutional arbitration in Europe, I was advised by SEMI, a council of a big company in Turkey who attends a current course in Switzerland, to come to Switzerland and spend 5 times 4 days with us in Switzerland, where we have a so-called Swiss Arbitration Academy, where institutional rules and others are practiced, not only in theory, but you work on a practical case throughout the 20 plus days in Switzerland. I promise you that you will learn a lot, and as I heard from Semi and other students, they found it was worth it. So that's a little advertisement section, and I thank you for your attention.
Thank you. Teşekkürler. 3. sırada tahkim konusunda bir yer edinmek için ciddi son yıllarda yatağa kalkmış olan Milano Ticaret Odası'nın bir kuruluşu diyebileceğim Milano Tahkim Odası'ndan Sayın Daniela Morante konuşacak. Mikrofonu kendisine veriyorum.
Good morning, everybody. First of all, allow me to thank the Union of Turkish Bar Association for inviting us. This is such honor and a pleasure being here. Before I start the presentation of our center, I would like to give you a little background, some information about arbitration in Italy. As far as the legal framework is concerned, in Italy, arbitration is regulated by the Code of Civil Procedure. Traditionally, the statutory provisions up to recent times were not arbitration friendly. In the last 30 years, we had 3 reforms which step by step brought us to a more liberal approach. And the most recent reform, dated 2006, has been regarded as an improvement to the previous legislation. So the current statutory regulation is inspired by UNCITRAL model law, and we can say that has brought us our legislation to international standards. Since we are talking of institutional arbitration, I think it's worth mentioning that Article 832 of the Code of Procedure finally recognized institutional arbitration, stating that the arbitration agreement may refer to pre-established arbitration rules. This is the legal framework. As far as the practice is concerned, I have reported here some data extracted from the 4th report on alternative justice in Italy. And as you can see, alternative justice plays a limited role in the resolution of civil claims in Italy. In 2009, we had about 5 million cases pending before our state courts, and we only had 93,406 reported cases handled through institutional mediation and other ADRs, and we had 802 cases, institutional arbitration cases. Out of these 802, 631 were administered by the centers attached to the Italian chambers of commerce. And the Milan Chamber of Arbitration is attached to the Milan Chamber of Commerce. So we administer 153 cases out of the 631. And you can see that in Italy we are the leader in institution for the administration of arbitration cases, and we also administer 62% of all the reported international cases. So we are definitely the point of reference in Italy also for the international community. As I said before, we are a special agency. We are attached to the Milan Chamber of Commerce. We are a special agency of the Milan Chamber of Commerce. A special agency, being a special agency, means that we are a private entity performing one of the regulatory market functions of the Chamber of Commerce, which is to provide the market with ADR services. The Milan Chamber of Arbitration is a generalist arbitral institution, which means that we administer arbitration cases concerning any kind of commercial disputes, both domestic and international. We are a multi-doors dispute resolution center, so originally we only had an arbitration service. Then along the years we have developed other services. We have a mediation service for national cases, an online dispute resolution service called Resolvi Online, and then we have a mediation service which is dedicated to disputes involving parties from Italy and China. Then a mediation service specifically dedicated to international dispute, and a domain name dispute service. These are our premises. We have conference rooms, and we also have hearing rooms, and where we host the arbitration hearings, and so parties can use these facilities, and they don't have to pay extra. We don't charge them because it all included in the administrative fees that parties have to pay to the institution. So I would like also to spend a few words on our international activities supporting arbitral culture, and in particular I would like to say a few words about the Mediterranean project, because it is very important to us, and I think that it's quite interesting. It might be of some interest for you too. This project was launched in 2005. It aims at developing arbitration and mediation in the Mediterranean area. It involves 7 countries, from Morocco to Syria, and included Turkey. The idea on which this project is based is that in order to spread arbitration, it's important to strengthen and consolidate the existing arbitral institution and help them, if necessary, to update their practice. So this idea brought us to the establishment of ISPRAMED, which is the Institute for the Promotion of Arbitration and Mediation in the Mediterranean. This association leads a network currently composed of 5 centers, among which the most important are the Milan Chamber of Arbitration and the Cairo Regional Center for International Commercial Arbitration. And we have other centers, and we also have among these centers the Istanbul Chamber of Commerce. We have created with representatives from each of the institutions involved a working group which is coordinated by Professor Charles Jarosson, and the working group is working on the elaboration of common principles which will inspire or guide who have joined the network in their practice. So hopefully the long-term objective is to have a common practice among those institutions in the Mediterranean area, and to guarantee to companies working in the area, guarantee that each institution of the network provides high quality arbitration service. So hopefully also in the future the Istanbul Chamber of Commerce will be able to provide a service which satisfies your needs. So now, with reference to our arbitration service, the Milan Chamber performs its tasks through two bodies, the Arbitral Council and the Secretariat.